Yes, Mr. Nafta.
Your lordships want me to read paragraph 4.
Just a few lines from that para and then we can move on to the next
one. Thing which I want to bring to your lordship's notice. This, if your lordship sees the first para of the judgment, where it refers to the presidential order of 1954, in the very first para of the judgment. Now, the Article 81 was amended, was modified with the concurrence of the state government. So there was a democratic element in that. Now, in this context, kindly see para 4. Some of the observations in para 4, as I said, are too wide. And if they are accepted in toto, the entire constitution of India can never be applied to Jammu and Kashmir. If taken to its logical conclusion. But even assuming that the introduction of indirect election by this modification is a radical alteration of the provisions of Article 81, the question still remains whether such a modification is justified by the word modification as used in Article 371. We are here dealing with the provision of a constitution which cannot be interpreted in any narrow or pedantic sense. So I pause here for a minute. Their lordships are now comparing Delhi law's case and this provision in the constitution. Now my humble submission is that as far as Delhi laws is concerned, it's ordinary statute. Therefore, there can be a more flexibility.
Yes.
But when you are dealing with a constitutional document, the limitations should be on a higher scale. This point is missed out. Kindly see further. The question that came for consideration in the Delhi law's case was with respect to the power delegation.
Yes, Ms. Nafte, I think we've got your point that, you have to have some implied limitations and therefore these observations in para 4 are of a very broad amplitude.
Your lordship sees the para 4.
We'll have to hear the other side. You made your point. We'll hear the other side on this.
Completely wipe out.
All right. What is the next point, Mr. Nafte?
So my next point is, which I will indicate at the end, because I have to deal with Article 3 and 4 as briefly as possible. But my next point is, what happens to the Constitution of Jammu and Kashmir? That's a thorny question. So if I recapitulate the facts which have been extensively set out in Premnath Kaul's case and which has been cited before your lordship.
So what is the submission on this aspect?
The submission which I want to make is this. So it traces out, the judgment traces out how the sovereignty came to be vested in the Yuvraj. Right from 1925 to 1951 or 49. And thereafter, two important developments. Yuvraj accepts the Constitution of India. But that is in the light of Clause 8 of the Treaty of Accession. Clause 8 recognizes that barring a few items, the sovereignty of the Maharaja remains. Now this sovereignty, which is recognized by the accession treaty, where and when does it evaporate? That's the question. Because as a result of this constitutional order and the Reorganization Act, the result is the Jammu and Kashmir Constitution comes to an end. Now let me elaborate this point, sir.
But that's postulated, and over the passage of time, period of time, what was left, as pointed out by Dr. Naval, was only limited, very, very limited. Small.
Several provisions came to be applied, no difficulty. But the core of the J&K Constitution has remained intact till end, which I will indicate to your lordship. So therefore, your lordship will see that it is in 1951 that Yuvraj convened the Constituent Assembly. to frame the constitution. What is the authority by which he could do so? His authority to convene a constituent assembly has not been questioned anywhere. So therefore, J&K constitution is a constitutional document. That's the only conclusion possible. Now my submission is going to be that no matter how widely you interpret the power under 371D, the core of the J&K constitution must remain. And what is that core? So kindly come to J&K constitution. That is in volume 2. So in the first place, the state.
So can you itemize the core? I mean, can you just sort of summarize what would be the core?
The core I am indicating, that is part 5 and part 6 of the J&K constitution.
That is the executive.
That is part 5 is executive and part 6 is the legislature.
Additional document volume 2. Additional document.
Sir, when the constitution was ushered in,
Which is one more provision? Part 5 is the
is the executive, governor, council of
Part 6
ministers,
is the
etc.,
legislature, and what else?
and the legislature.
These two.
And kindly see,
You said one more.
section 3 and 4. Sections 3
Document compilation. Document volume.
and 5.
What
That
are we-
is part 2.
Yes.
Now the state of Jammu and Kashmir has its origin also in this, its continuation.
Additional compilation.
It originally existed. There is a long history which has been set out in Ramnath Kaul's case, right up to independence, 1947 Act, Treaty of Accession, etc. Now kindly see the territory, section 4,
volume 2 में
Constitution.
पूरा वही document है.
The territory, the PDF page is 18. The territory of the state shall comprise all territories which on the 15th day of August 1947 were under the sovereignty and sovereignty of the ruler of the state. Now this is the territorial integrity of the state. Now there is no provision in the Constitution of India by which the J&K Constitution can be abrogated. There is no express provision. The only question is whether through the route of 371D this can be achieved. Now this depends upon the question, because Article 370 itself recognizes the Constituent Assembly. And the concept of Constituent Assembly is that it's a sovereign body. Now there can be a constitution within a constitution. That is something which your lordships have recognized. I'll just indicate to your lordship. That your lordship will find in the judgment of Yeshwananda Bharati. Para 2072. I just indicate PDF page 79091,
Volume,
volume 15, sir.
We'll look at it. Page, just give us the page 70,
790.
which says that there can be a constitution within a constitution.
Constitution.
All right.
That's what
Whose judgment is that?
Justice Chandrachud. Now, therefore, your lordship see the existence of level portion.
you should write that. एक बात तो
Yes.
Thus, the true ground of division by virtue of which the nature of the constitution is whether it is flexible or rigid, that depends upon whether the process of constitutional lawmaking is or is not identical with the process of ordinary lawmaking. A typical instance of flexible constitution is that of the United Kingdom. The constitution of the former kingdom of Italy was also flexible, so flexible indeed that Mussolini was able to profoundly violate the spirit of the constitution without having to denounce it. The constitution of the United States is rigid as it cannot be amended without the special machinery being set in motion for this purpose. In short, we may say that the constitution which cannot be bent without being broken is a rigid constitution. The Indian constitution, considered as a whole, is a controlled or a rigid constitution because broadly none of the articles of the constitution can be amended otherwise than by special procedure prescribed by Article 368. Certain provisions, therefore, like Article 4, read with Articles 2 and 3, Article 169, Para 7 of the 5th Schedule, and Para 21 of the 6th Schedule confer power to amend the provisions of the Constitution by ordinary lawmaking process. But these amendments are expressly accepted by the respective provisions from the purview of Article 368. Schedules 5 and 6 of the Constitution are in fact constitution within a constitution. So therefore, the existence of J&K Constitution is recognized by the Constitution of India. How do I show that? Kindly turn to Article 370.
That you need not labor because according to you, the
It refers to.
Constituent Assembly itself.
Now the question therefore is that if the Jammu and Kashmir Constituent Assembly was convened by a sovereign authority, that sovereignty merges into the sovereignty of the Constituent Assembly and it ultimately gets transferred to the Constitution of Jammu and Kashmir. Now, therefore, you have two sets of documents. Article 371D, if it is deployed in such a manner that it results in the complete abrogation of J&K Constitution, is something which is, in my respectful submission, not contemplated.
All right. What is the next point, Mr. Nafide?
So my next point is, now, originally there were two routes. One was 373 itself. After 1957, that route is closed.
Yes.
Then we take recourse to Article 368. So in Para 7 of the judgment in Sampat Prakash,
Para?
Para 7 in Sampath Prakash.
Yes.
It was relied upon by Mr. Dave. I don't wish to therefore repeat that.
Para 7 of Sampath Prakash.
Sampath Prakash.
What is the submission on that?
Justice Dave, Mr. Dave said that your lordships in this judgment have recognized that Article 373 is still in force. This is much after 1957. Now that route is obviously closed. But Sampath Prakash goes a step forward and says that even with reference to 368, you can't do it. Para 13. Para 13 of Sampath Prakash, I'll show to your lordship that your lordship will get PDF, volume 1, PDF 33. Now this, in my respectful submission, is no longer good law. In view of what the 11 judgments in Keshavananda Bharati say. Every judgment in Keshavananda Bharati says that every part of the constitution can be amended. Of course, some judgments take a view subject to the rider that basic structure can't be touched. But there is not a single judgment in Keshavananda Bharati which carves out an exception. And therefore, in my respectful submission, the only route which was constitutionally permissible is through 68.
That's what Mr. Dave has also argued.
Yes, that's what. So therefore, to that extent, para 13 of Sampath Prakash is not a good law. But para 7 remains. So therefore the question of what do we do with J&K Constitution? The core provisions, as I said, part 5 and part 6. The executive and the legislature of J&K are created by J&K Constitution. Now, by reference to Articles 3 and 4, by taking recourse to Article 3 and 4, these constitutional provisions contained in J&K cannot be done away with. So two submissions in this regard. The framers of the Constitution were aware of the fact that the Constituent Assembly for J&K is in the offing. Clearly reflected in Article 370. Now, therefore, the question is that does it not contemplate when it says that provisions, this Article 370 special status, provisions of the Indian Constitution can't be applied unless you follow a certain procedure. Does it not contemplate clearly that the Constitution of India, as framed by the Constituent Assembly, recognizes the existence of J&K Constitution? And therefore, doing away with that can only be through a constitutional process. Now, therefore, your lordship will see that this is a limitation. The existence of J&K constitution is a limitation both on the power of the president under Article 371D, also the parliament's power under Articles 3 and 4. So part 6 of the Indian Constitution has never been applied to Jammu and Kashmir, except a few provisions here and there. But the core, the executive and the legislature, those provisions contained in the Indian Constitution have never been applied to J&K. In the judgment in NCT of Delhi versus Union of So this is the 4 characteristics which your lordships have written. In paragraphs 292, 290, 291, 292, 296, 298 and 305. So kindly see what your lordships have said. The framers of the constitution were aware of the challenges which the new instituted democracy could face. In his address to the Constituent Assembly, but kindly come without to the straightaway to 305. This is the discussion which I don't wish to trouble you. PDF page 160. There are 4 abiding principles which are essential to the understanding the content of the Constitution. The first is that as a political document, the Constitution is an expression of the sovereignty of the people. This is satisfied by J&K Constitution because the Constituent Assembly was convened by the Maharaja, Yuvraj, because of clause 8 of the accession. The second is that the Constitution seeks to achieve its vision of a political and social ordering on the basis of democracy. A democratic form of government recognizes that the sovereignty resides within the people. Popular sovereignty can exist when democracy is meaningful. This is also satisfied. The third principle is that the Constitution adopts a republican form of government in which the powers of sovereignty are vested in the people and are exercised directly or through their elected representatives. This is also satisfied. The fourth, which is not the least in importance, in the secular ideology of the Constitution, for it is on the foundation of secular order that freedom, liberty, and dignity and equality to every citizen achieve. Now, if these are the 4 characteristics of a constitution, then in my respectful submission, J&K Constitution satisfies that. Now, when we talk of sovereignty, it does not necessarily contemplate external sovereignty. I accept that the concept of sovereignty vis-a-vis J&K is not external sovereignty. Because defense, foreign affairs, etc., the subjects were already accepted in the accession treaty. I am not therefore suggesting for a moment that this sovereignty is absolute in the sense in which that concept is understood in international law. I wonder whether even the current scenario under the international law, is there anything called absolute sovereignty? Because there are so many conventions by which the state bind themselves. And your lordships have recognized that your lordships courts can enforce the international conventions, though India may not have ratified them. So therefore, the absolute sovereignty concept, which was some 200 years ago, is no longer exists even in international. But the fact remains that that concept of sovereignty has some content. And that content with regard to Jammu and Kashmir is that their internal affairs be conducted at least in accordance with Part 5 and Part 6 of the J&K Constitution. A 371D can make only marginal inroads. Anything beyond that, which results in the constitution of J&K evaporating, you can never have been contemplated. Now, in the alternative, even if we accept the concept of internal sovereignty, with respect to other states, keep aside Jammu Kashmir, because people get obsessed with the concept of special status. Forget the special status also for the time being. But your lordships in Bomai have quoted with approval a passage from Sirwai's book, which talks of internal sovereignty. Your lordship may have a look at that para. That is para 97. It is PDF
Volume,
volume 2,
page.
page 113.
Para.
Para 97, sir. Where Sirwa has been extensively quoted. Therefore, every state in this country has internal sovereignty.
Para?
Para 97. PDF page 113. Where Sirwa has been quoted extensively. I don't wish to read that entire portion. But kindly see B clause, the subpara B on page, PDF page, next page, your lordship, 114. The parliament's power to alter the boundaries of states without their consent is a breach of federal principle. And subpara D, external sovereignty is not relevant to the federal nature of a constitution, for such sovereignty must belong to the country as a whole. But the division of internal sovereignty by a distribution of legislative powers is an essential feature of federalism, and our constitution possesses that feature. Now, if this is so with regard to the other states, much greater weight must be applied to J&K constitution.
Yes, Mr.
So in Santosh Gupta's case, 2017 to SSC, which your lordship will find in volume 1, PDF page 136.
What are you citing it for?
This is because this judgment says that J&K sovereignty has come to an end. Probably the Union of India wants to rely upon that judgment. That is how it has come in the. So I wish to point out to your lordship that what was the issue in this matter? The issue was whether the provisions of the Surface Act applied to J&K or not. There was a constitutional challenge, which was upheld by the High Court. And the High Court referred to in the judgment several times the sovereignty of the J&K. And also said that this does not fall within the list 1. Now this judgment takes a view, if your lordships look at paragraph 43 and 44 at PDF pages 133, that Surface Act falls principally within the provisions of, within the ambit of entry 45 and entry 95, list 1. That's the finding in paras 43 and 44. Now, having come to this conclusion, that since it falls in entry 45 and 95, the list 1, the question whether J&K constitution had sovereignty or not does not survive for consideration. Therefore, this is an arbiter applying the test which Chief Justice Chagla applied in that Bombay judgment, which incidentally I forgot to refer. It is there in volume 29.
We look at it, yes.
I just read out. So page 5 of that. This is what his lordship. But the question still remains as to what is an arbiter dictum given expression to by the Supreme Court, which is binding upon the courts in India. Now, an arbiter dictum is an expression of opinion or point which is not necessary for the decision of a case. This very definition draws a clear distinction between a point which is necessary for the determination of a case and a point which is not necessary for the determination of the case. But in both cases, points must arise for the determination of the court. Two questions may arise before the court for determination. The court may determine both, although only one of them may be necessary for the ultimate decision of the case. The question which was not necessary for the determination of the case would be ratio decision. The opinion of the tribunal on the question which was not necessary to decide would be only an arbiter. I don't think that this view can be found fault with. So therefore, in para 47 in Santosh Gupta's case, his lordship says that sovereignty has come to an end. In the first place, this is clearly contrary to in Premnath Kaul's case, which has been cited by Mr. Dhawan. I just want to show to your lordship only one observation from Premnath Kaul's case that your lordship will find. That is para 16 of that judgment. What is the PDF page? Well, second line from the top, we have no doubt that the URAD was perfectly competent to issue the proclamation of 20th April 1951, under which the Constituent Assembly ultimately came to be elected and convened. If the Constituent Assembly was properly constituted and it decided not to pay any compensation to the landlords, it is difficult to understand how the validity of these decisions can effectively be challenged. Your Lordships have specifically recognized the power to convene a Constituent Assembly. That's an act of sovereignty. So there is one more para. He has read para 42. Who has read? Yeah. I'm sorry, I read para 42, not para 16. I stand corrected. So therefore, in my respectful submission, the observations in para 47 in Santosh Gupta's case to the effect that the sovereignty has come to an end is clearly contrary to Demnock Kaul's case. In any case, it's an arbiter. In any case, there is not much of discussion in that judgment on this issue. And it's a judgment of only bench of 2 learned judges. So my next point is Article 356. Much has been said by Mr. Dave and others, but there is one aspect which I want to bring to your highlight. It may be an overlap, but there is particular aspect which I want to emphasize. What is the effect of the presidential proclamation? So kindly turn to Article 355. What is the purpose of 346 or 356? There is breakdown of the machinery, accepted. The affairs of the state cannot be carried on in accordance with the Constitution, accepted. But does that justify doing something which is unconstitutional? So in the first place, the J&K Assembly was dissolved in November 2018 and the governor assumed the powers. He assumed the powers under the J&K Constitution. And not the 356 proclamation came in December 2018. This presidential proclamation under 356 is clearly without jurisdiction. Clearly without jurisdiction. The reason is that the governor has already dissolved the assembly. The governor has assumed all the powers of the state. Now, certainly the governor assuming the powers can't be a breakdown of the state machinery. It would be absurd to suggest that, and therefore President has to intervene under 356. It's a jurisdictional issue. And 356 has been invoked for a collateral purpose. And that collateral purpose is apparent on the face of the record. You suspend the 2 provisos to Article 3. The first proviso which applies to all the states that you can't alter the boundaries, change the name of the state, etc., without first giving an opportunity to the state concerned to express its views through its legislative assembly. You suspend that. Second proviso, which applies to J&K without the consent of the legislative assembly of J&K. Now, I cannot understand if there is breakdown of the machinery, what is the necessity, what is the rational nexus to suspending these provisos? There is an implied limitation on this power. Can you suspend the entire constitution? Because the president has issued proclamation under 356. Once you accept that there are implied limitations, the suspension of any part of the constitution as a result of presidential proclamation under 356 must have a rational nexus to the objective that is to be achieved. And the objective that is to be achieved is Article 355. Kindly see Article 355. The duty of the center. It shall be the duty of the Union to protect every state against external aggression and internal disturbance, and to ensure that the government of every state is carried on in accordance with the provisions of this Constitution. Now read Article 355, 356, 357 conjointly. And the only result is that the state as an constitutional entity must survive. Now, what is the purpose of suspending the proviso? Ultimate design is abolishing the state of J&K. Contrary to the mandate of 355. Therefore, your Lordship will see the J&K Reorganization Act is born, is conceived in an unconstitutionality. Patent. Now let me test even the wording. I have shown to your Lordship the context, but kindly see what 357 says. Sorry, 356C. Make such incidental and consequential provisions as appear to the President necessary or desirable in giving effect to the objects of the proclamation. Now, suspension of those provisos, what is the nexus? In the entire affidavit of the Union, I don't find any light being thrown on this aspect of the matter. Then kindly see 357. (357) 1B. For Parliament or for the President or other authority in whom such power to make laws is vested under subclause A to make laws conferring powers and imposing duties or authorizing the conferring of powers and the imposition of duties upon the Union or officers and authorities thereof. Now this is a power to make law. The way Dr. Dhawan, everybody has argued that 356 is a temporary thing.
भाई को पूछो कि क्या
is this, that the power or the function that the state assembly performs under the provisos to Article 3 are not power of making law. Article 357, 356, they refer to the state legislature's power to make law, which is taken over by the parliament or by president by issuance of ordinance. But this is not that power. The power under proviso is not law-making power at all. And this is recognized by judgment in Keshwananda Bharati's case. Again, I have to refer to Justice Khanna's just observation. And that is para 1351, which volume 15, PDF 542. So this is with reference to proviso to Article 368. But the logic would equally apply to proviso to 3, Article 3, my submission.
And your argument is that 357(1)(a) provides for Parliament to confer on the President the power of the legislature of the state to make laws.
Make laws.
And that function which you discharge under the proviso to Article 3 is not the power to make laws. We got it.
Not law-making power.
We made the point.
Yeah.
What's the next?
So therefore, it can't get the president can't take over that power.
Just give us the
1351.
volume.
1351. Articles 248 read with entry 97 list 1 contemplates legislative process. If the amendment of the constitution were such a legislative process, the provisions regarding ratification by the legislature of states.
What is the PDF page? PDF page?
542.
Yes.
Article 248 read with entry 97 list 1 contemplates legislative process. If the amendment of the constitution were such a legislative process, the provisions regarding ratification by the legislature of not less than one half of the states in respect of certain amendments, the constitution would be meaningless because there is no question of ratification of a legislation made by the parliament in exercise of the powers conferred by Article 248 read with entry 97 list 1. It is noteworthy that the ratification is by means of a resolution by the state legislature. The passing of a resolution can plainly be not considered to be a legislative process for making a law. The state government also do not come into the picture for the purpose of ratification, etc. So therefore, your lordship sees that everything that the legislature does is not necessarily law-making process. So therefore, the powers under the proviso would have never been taken. So therefore, Article 356 proclamation suspending those two provisos which have no nexus whatsoever to the object to be achieved under 356 clearly collateral. So now I come to interpretation of Articles 3 and 4. So the reference I made to Article 355, but some passage from Bomai I must show to your lordship. Para PDF page 155
of
of volume 2. Now kindly see what that para says. This is with reference to Article 355 on which I place reliance. That the purpose of 356 is to restore the state. Para 160. The crux of the question.
Just 1 second, which page are you reading?
155.
155.
The PDF page 155.
Which judgment is this?
Bomai.
Volume 2. Para 168.
Para
160.
160.
160.
I think judgment of K. Ramaswamy. The crux of the question is wields of the President's power under Article 356. This has a direct bearing. It finds its birth from a family of emergency provisions in Part 18 of the Constitution. Article 355 imposes duty on the Union to protect states against external aggression and internal disturbance and to ensure that the government of every state is carried on in accordance with the provisions of the Constitution. As a corollary, when the government of the state is not being carried out in accordance with the provisions of the Constitution, a constitutional duty and responsibility is put on the Union to set it right. So therefore, if the machinery has broken down, to set it right means to see that the state normalcy is restored. So therefore, Article 356 cannot be read in isolation. The purpose of 356 is to restore under Article 355. That's the purpose for which. Now, another reason to say the same thing is said by Justice Jeevan Reddy and paragraph 272 and Justice Sawant at para 56-57. I did not read those paras, I'm just giving to your lordship those parameters. So the sum and substance of Bomai is this, that restore the state to normalcy because that's a duty cast upon you under Article 355. Now there is one more reason to say that the exercise of power under 356 is for a collateral purpose. Because ultimately what they want to achieve, get away with, do away with Jammu and Kashmir state. That point I already made. I have also said no jurisdiction because the governor had already assumed the powers after the assembly was dissolved. There is one more reason which is to be found in judgment of this court in K.N. Rajgopal versus Karunanidhi. 1972, volume 4 SCC, page 733. PDF page 68-69.
Of which volume?
So PDF page 68-69, volume 19. It's a one-page judgment, but has seminal contents.
Volume?
19.
Paragraph, there is only one-page judgment. It is volume 19, PDF page 68-69. So this is what your lordships have said. We have just delivered a judgment in so and so. A similar question arises in this appeal, but with respect to the Chief Minister and the Minister of the State of Tamil Nadu, the relevant articles are worded similarly. The only difference is that the governor is not elected, but is appointed by the President under Article 155 of the Constitution and under Article 356 of the Constitution, makes a provision in case of failure of constitutional measure in the state. But when an assembly is dissolved, there is no failure of the constitutional machinery within Article 356, Article 164, which provides that the Council of Ministers shall be collectively responsible to the Legislative Assembly of the state, has to be read in Article 75(3), following our reasoning in that appeal, this appeal was. In other words, what your lordships have said is that once the assembly is dissolved, there is no question of machinery having failed, and therefore consequently there can't be a 356 exercise. So in this context, I invite your lordship's attention to judgment in Gujarat Assembly case. Now, if your lordships have a look at Article 356, there is no provision which says that what is the upper limit. How long you can do away without an elected government. This question came up before your lordship in Gujarat Assembly case. And your lordships have said 6 months. I'll just say that judgment is in volume 19, PDF page.
Page? Volume 19 page?
Does it?
Page, volume 19 page?
I'm just reading. Page 283. Which is the parallel?
Volume 18, page 28.
So kindly come to para 79 on PDF page. The PDF page. 283, sir.
283.
Para 79. However, we are of the view that the employment of the words and expiration occurring in section 14 and 15 of the Representation of the People Act respectively show that the Election Commission is required to take steps for holding elections immediately on expiration of the term of the Assembly or its dissolution, although no period has been provided for. Yet, there is another indication in section 14 and 15 of the Representation of the People Act that the election process can be set in motion by issuing of notification prior to the expiry of 6 months of the normal term of the House of the People or the Legislative Assembly. Clause 1 of Article 172 provides that while promulgation of emergencies is the operation, Parliament may by law extend the duration of the Legislative Assembly not exceeding 1 year at a time, and this period shall not in any case extend beyond a period of 6 months after the promulgation has ceased to operate. Further, under Article 123(2)(1)(3) of the life of an ordinance promulgated either by the President or by the Governor, as the case may be, is 6 months, and repeated promulgation of ordinance after 6 months has been welcomed by this court. Again, under Article 109, 110, and 111, and analogous articles for the State Assembly, money bill has to be passed by the House of the People or by the Legislature. So the period of 6 months has been read by your lordships. Then there is one more para of in the same judgment. This was of Justice Khare, and there is para 147 in the judgment of Justice Prasad. PDF page 316. So this is the ratio. Para 147. Almost his lordship has echoed what Justice Khare has written in that 79 which I read out. Now I come to Article 3 and 4. Now kindly see the marginal heading. formation of new states and alteration of areas, boundaries or names of the existing states. This is a clue. Of course, there is a debate whether marginal headings can be seen or not. But fortunately for us, this issue is no longer res integra, as a constitution bench judgment of this court in Bengal Immunity versus State of Bihar 1955 2 SCR, page 603, or AIR 1955.
What will be the PDF page and volume?
PDF volume 13, and page is PDF page is 144, and I take straight away your lordship to para 25.
It can indicate the general drift of the provision, but it cannot be used to supplant the actual statute.
That's correct.
The
I'm not
actual
saying-
words of the provision.
I'm not saying. If there is some ambiguity, and there is in my respectful submission, according to me, there is not even ambiguity, there is a conscious omission in Article 3 as regards power to abolish a state. Conscious omission. So why do I say there is a conscious omission? Not only from the marginal heading, but also look at the text. Form a new state by separation of territory from any state, or by uniting two or more states or parts of the state, or by uniting the territory to a part of a new state. Minute details, what that power is. Then it further says, increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state. Details are given. What is the extent of that power? There is no ambiguity at all. There is not even a whisper about abolishing a state. And this has to be seen in the light of Article 1. India, that is Bharat, shall be a union of states. Two also. The Parliament may by law admit into union or establish new states on such terms and conditions as it thinks fit. So Article 1, India, that is Bharat, is the union of states. Article 2, admission of new states. Article 3 gives details of the power that the Parliament has. Now, therefore, there is a conscious omission to abolish a state. My second point.
What happens when you unite two states?
But the point is this, your lordship will see that a territory, what is the idea behind the state? That people in a given territory should have a state government. two-tier democracy at the state level, and that is how the constitutional scheme is. Some powers are given to the state, these two. They have their own government. So this concept of a state is inbuilt in a democratic structure that this constitution has built. In other words, the existence of states is a part of the basic structure. And J&K can't be an exception to it. Then why not tomorrow abolish Bengal? By what parameter? That according to me, there is a conscious omission. So Article 1, 2, 3 have to be read together. Now, there is one more reason. This alteration of boundaries, changing the name of the state, uniting two states, one state being divided into number of states, this does not amount to an amendment of the Constitution. True. So all the more reason why this power must be narrowly construed. According to me, no two interpretations are possible. There is a conscious omission to abolish a state because India is the union of states. I link it with 355 and 356. Article 3 has to be read with 355. If there is breakdown of machinery, restore the normalcy. But you can't abolish a state. And since it does not amount to a constitutional amendment, it must be strictly, narrowly construed. And this interpretation, in my respectful submission, would advance the concept of democracy and concept of federalism. Open the Article 18. Article 18. Last of my argument. Now forget everything. What is the impact on the constitutional structure where everything has been turned upside down? First, what is the impact? Ladakh, under the reorganization, has no representative in the Rajya Sabha. People of Ladakh therefore do not count as far as Rajya Sabha is concerned. So much for the democracy. Now look at Lok Sabha. All existing Rajya Sabha. All existing 4 seats in Rajya Sabha go to J&K. Ladakh is left out. Consequently, people of Ladakh have nothing to do with working of Rajya Sabha, including the election of the deputy chairman under Article 89 and 90. Second, look at Lok Sabha. Under Article 81C, all union territories in the country can maximum have 20 seats. In that, you have the J&K. But look at the discrimination. Under Article 81, Clause 2, as far as other states are concerned, the number of seats that they have depends upon their population. And the Constitution further mandates that this ratio between the population and the seats for all the states shall be same as far as practicable. So in state of Jammu and Kashmir, irrespective of its population, it has no proportionate representation in the Lok Sabha. Discrimination. Article 14. Now, if you create some more union territories, that limit of 20 will have to be crossed. Today it is 19, including the 5. That's all right. But look, if working out seats for other states is a different formula. How can this be done? Other disastrous consequences. Look at the election of the president. Come to Article 54 and 55. For electing the president, the electorate consists of members of parliament, both Rajya Sabha, Lok Sabha, and also the legislative members of respective states. Now, J&K is not a state. Therefore, there is no MLA for the purpose of president's election. Now, to the exclusion of such a big area, no say in the election of the president, if not by direct, at least by an indirect method. But I must hasten to add that the Reorganization Act says that J&K will have the same rights as Pondicherry. And Pondicherry under Article 54 and 53 there, but this will require a constitutional amendment. You can't do it by law like this. Other disastrous consequences, Article 279A, representation in the GST Council. People of Jammu Kashmir, Ladakh have no say as far as that council is concerned. Appointment of High Court judges. As far as other states are concerned, the governor is one of the persons to be consulted, and governor means aid and advice. So that also goes away. There are several such provisions in the Constitution which are impacted. Therefore, by a very small act which apparently looks constitutional, that is Constitutional Order 272, the whole constitutional structure is demolished, substantially restructured vis-a-vis J&K. I am grateful that
Thank you, Mr.
I
Nakde.
exceeded my time.
No, Mr. Nakde. Thank you very much. Thank you, Mr.
And
Nakde. Who will-
both Mr. Dave and everybody has argued that consultation contemplated must be effective. That is why elected. That point has been extensively argued. So I'm sorry that I exceeded my 1 hour.
Thank you, Mr. Nakde.
But
Thank you.
I thought in the circumstances,
You come.
perhaps I was justified. I am grateful. Manu.
Somebody's time will have to get deducted.
Ultimately, whether it's a 20 over, 50 over, the time is allocated to everyone between whatever is available.
How much somebody can bet will depend on the total number of hours.
Since your lordship used the word bat, Lord, it reminds me of my position at this point of time is like that of a night watchman.
No, you're just after tea, actually, so you have a whole session you can resume.
Which is a very delicate job, night watchman, no? He has to sustain the flagging interest also. But I have submissions on two issues only. One was what Mr. Nakde was advocating just now regarding demolition of a state into union territory. And the only thing I wish to add on what he said was, if Lordship would just have a look at 246(4).
Is it way?
Which matter are you appearing, Mr. Devadi?
Correct number de do inka.
No,
Yeah, it's
in
not.
the first matter, Lord, we filed a petition, but we were told to file a intervention application, and then an order was passed on that we will be heard like any other petitioner. Therefore,
So you are for an intervener,
yes.
which just give us just a reference so that, we can, just for the sake of the record, we need to complete the record.
Lord, it is writ petition number. It is IA number 145.
IA number,
2.
sorry, can you come again, please?
IA number 145
Yes,
852
yes.
-53 of 2019. This is in writ petition civil number 1013 of 2019.
Actually, 18 forward to
overruling, Lord, inevitably implies that the past practice, whether right or wrong, it will continue to operate and will not be affected by the judgment. But it accepts the fact that if the declaration is made of invalidity of the impugned amendments, then that may have a consequence, and therefore lordships prospectively overrule it. So implicit in this prospective overruling is the invalidity of those supposed invalidity, and therefore lordships try to save it. Now, Lord, another way of looking at it is, Lord, look at it this way. Supposing lordships accept my viewpoint on the basis of the text and the context, and lordships come to the conclusion that yes, there is a case for this, that the power is not available, and therefore the impugned COs are invalid. Now, in order to prevent the effect from traversing on to the earlier ones, your lordship would ask whatever relief lordships can mold under 142, lordship would do that. But that doesn't mean, Lord, that on the basis of this past, continued exercise of power, your lordships would ignore the text and the context. If the text and the context, as per my submission, inevitably show that yes, the power could not have survived beyond 57, then perhaps, Lord, there is a case to look into it.
All right. Now, Mr. Devadi, should we start with the first point? Because first you have to add on to what has been argued by Mr. So maybe just because we are at about 3:35, so you can maybe in 5 or 10 minutes conclude the first point.
What I wanted to add was, apart from what my friend had said, additionally, if your lordship would just have a look at 246(4). Lordships have had a look at it, there's several occasions, but then my friend perhaps omitted to see it. 246(4). Parliament has power to make laws with respect to any of the matter for any of the territory of India, which is union territory, not included in a state, notwithstanding that such matter is a matter enumerated in the state list. Now, that's the inevitable consequence of when you break down the state into a union territory, then Parliament is the sole legislature. Now, when Parliament becomes the sole legislature, Lord, then inevitably, Lord, the state comes out of the federal structure. Because lordships have said, Article 1, and my friends read some part of it, Lord, I can read some part of it too. Lord, Article 1 says India is a union of state and refers to Schedule 1. I feel lordship would just have Schedule 1 for a moment. Now, Schedule 1, Lord, specifies the states in Article 1 and 4. First schedule. It specifies the states, and Kashmir is there at item 15. And then, Lord, it goes on to have item 2. The lordship would have, Lord, 28 states. Then item 2, union territories. These are not specified as states. Now, though they are part of territory of India, as per Article 1, yet when it comes to federal structure, Lord, union territories are not part of that federal structure. This is, Lord, there are decisions I have referred to in my judgment, and the decision to that effect, Lord, that Article 1 does not contemplate union territory constituting part of federal structure. And for obvious reason, Lord, if your lordship would recall the definition of federal structure in our constitution given by Dr. Ambedkar, he said there has to be a dual polity. And that is how he declined the entire objections to the Constitution of India as being unitary and not being federal. Your lordship would recall.
Now there is a nuance on that. Following the NCT judgment,
yes,
we have placed Delhi in a different.
And I was coming to that only. Lord, it goes further.
Position.
what your lordship has said goes further. What it says is that dual polity contemplates that citizen of every state is entitled to be governed by the laws made by two different legislatures. That's the concept of dual polity. Where for local issues, the right is for the local to get himself governed by the local legislature on local issues. And so far as the national issues or bigger issues are concerned, Parliament. That right gets defeated. And therefore, the dual polity gets lost as per Lordship's judgment. States are not appendages, as the Lordship said, not satellites of the Union. They are their own plenary selves created under the Constitution, not the Parliament. So this results in the demolition of the entire dual polity and therefore destruction of the federal structure. And no one can say, Lord, the Jammu and Kashmir did not satisfy the requirement of federal structure. Our federal structure is not defined, but there's an interesting aspect which I wanted to bring to your Lordship's notice in this regard. Lord, all throughout, we have been hearing about the quasi-federal character and so on and so forth. It's not truly federal as the American system in our Constitution. But in each of these judgments which say so, what your Lordship would see is they omit to notice the Constitution of Jammu and Kashmir. And when we come to Constitution of Jammu and Kashmir, it goes one step ahead of any other constitution, and that is this. It is the Constitution of Jammu and Kashmir in our federal structure which lays down the parliamentary jurisdiction. It lays down the parliamentary jurisdiction under the commitment given by the framers of the Constitution and the Dominion of India. It lays down the tone and terror of the state and the union relations. Finally, that's what the framers have said. And then have a look at Section 5. Because if you don't accept this fact, Lord, then Section 5 becomes, which is according to me, the soul and heart of the JK Constitution. That gets absolutely demolished. That's the basic structure of the JK Constitution. And Section 5 says the power of state would be not on any subject which is given to the Parliament. Parliament has been given enumerated powers, that is entry 1 to 96, and not 97 and Article 248. So which means residuary entry is not there. Rest of the entries 1 to 96 are there with Parliament under the Constitution of JNK. The concurrent list and the state list are with the state, except to the extent, Lord, that correspond to the instrument of accession. Now, can you look at this, Lord? Here is a case where the state is going to decide what is the jurisdiction of Parliament and what is the center-state relations, scope of that. So that's the extent to which the autonomy was given to JNK, guaranteed autonomy. And to borrow Dr. Rajiv Dhawan's phrase, Lord, it is democratization of power in India in the shape of autonomy. He referred to various provisions, various levels of autonomy was given. Now, here is a case where the level of autonomy is stupendously raised. But nevertheless, it is part of federal structure. We can't deny because Article 1 and the schedules say so. But by reducing that state into a union territory, what we are doing is we are bringing it under 246(4), where the people of the state, both the union territories now will have only one legislature, both for local and the national issues. The right to be governed under a dual polity goes for a toss. And that is how we'll have to see Section 3, Article 3, I'm sorry. Berubari gives a clear indication. I'll show that passage. But that is how we'll have to see. The power is limited. We can't, the amendments that have come is only for a specific object. And the object amendment in the, by adding the explanations to Article 3. They have come for a specific object of overruling the Berubari case, to the extent it said that union territory is not governed by. So to that extent they overruled. But the remaining part of Berubari judgment which says that states cannot be, they don't have a territorial integrity, the word used. But then they cannot be, they can be addition to the state, they can be subtraction from the state by giving it to another state. That way, what you are conferring is the dual polity. Whenever you change the territory of the state, you are retaining the dual polity for the citizens. Because from this state, they go to another state where the dual polity continues. But then by demolishing it, what we are doing is reducing and demolishing the dual polity into a unitary system under 246(4). That is what I wanted to add to my friends. And I have in my written submissions, given the host of cases where lordships have said this federal structure cannot be disturbed. This is my written submissions, and this is, I would request lordships to see page 44 and 45 in that regard. 44, 45. This is at page, as my friend corrects me, I have given the internal page, page 40, page, PDF page, no.
The written submission what?
What is the PDF page?
394.
The internal page is 44 and 45. So therefore, I submit to this effect, Article 1 completely excludes union territories, and therefore, once you reduce the state into a union territory, you deprive me of my right to be governed by two legislatures. That's the crux of the dual polity. Internal page 44 would be at page 437 of the PDF.
437.
437. And I'm only referring to page 44 to 46, and I've referred to a host of judgments, which lordships are clearly aware of. No? But basically, referring to two last judgments, if lordship would see, at page 46, internal page 46, two last judgments, no? Of which one of the Chief Justice was a partner, 2017-12 SCC 1, this is general, and then 2018 volume 8 SCC 501, and I have given the paragraphs too.
2018?
2018 volume 8 SCC 501, and I've given the paragraphs also in the PDF.
Yes.
And then there is another page lordship may have, no? 46 and 47, internal page.
Yes.
That is what I wish to add. No? Now, before I proceed, Lord, there were two issues which were rankling in lordship's mind, Lord, from the very beginning, first day. One was, in fact, two from her lordships, and one from Lord Justice Khanna. Lordship had an issue with regard to sovereignty, and the observation was that once you accede to the dominion of India, you surrender all your sovereignty. Now, lots of things have been, I'm already informed you, just that instrument of accession would not amount to surrender unless there is a merger agreement which says that you merge your sovereignty, as happened in the case of other states, which I will show. the other states had not only not acceded before 15th of August 47, they had signed as a precondition made by the Dominion of India that they will sign the standstill agreement also, which covers the matters of local concern. And after that, Lord, they acceded to the Union of India. Thereafter, Lord, they further, when they merged with the adjoining states, the adjoining provinces, provinces automatically merged, provinces under the Government of India Act, they automatically merged. Indian states merged primarily with the provinces, or they formed their own federation. Then they were directly administered states also. They all signed the merger agreements with the Dominion of India, conceding all their powers of legislation. And that is why, Your Lordship would see Article 238 was incorporated. Article 238, Lord, expressly applied Part 6 and 7. And of course, consequently, Part 11, which is 245, 246, 254, and so on and so forth, to all the other Indian states. But when it came to Jammu and Kashmir, Lordship would have noticed that in 370, clause 1, to 38 is excluded. This is despite the fact, Lord, what is important is this is despite the fact that the Kashmir was placed as a Part B state in the schedule that point of time when the constitution was enacted.
Now on the new point, it's about 10. Roughly, how long would you take? Because we are starting the new point, the second, the
Not more than an hour, no? Not more than an hour.
could we,
I tried.
could we continue
some
to
things
this
have been
because we'd
said.
like to conclude the submissions on this side on Tuesday.
Quite right.
Frankly, I'll tell you, now we've got so much of information from you, we'd like to put it to the other side and get
Information
responses. I
overload.
think you have,
No, but my situation is not, I'm like a pariah.
now
Not
just-
my friends are on different issue. I'm on an
No,
entirely
no.
different issue.
if you could really put it down in say about half an hour or so, so that we can push through on Tuesday and
I'll try my best.
after Mr. Dwivedi, who will be arguing? Mr. Singh, about half an hour or less. You've prepared your written submission. Your written submissions are there, right? So what we'll do is on Tuesday, frankly, I had not seen your submissions over the weekend. We'll look at your written submissions so that then, you know, your time is then, because we'd be completely ready with your background.
Can I make a request?
Cut it down to half an hour, Mr. Singh. Otherwise, you know, we'll not finish this side on now.
See,
Now,
Mr. Seyu Singh, see, Gopal Shankar Narayan has been sitting all this time. Therefore, he must now decide who is speaking and how long they are speaking, because the Gullentine will apply on Tuesday, certainly. Therefore, it should not be that one person takes an extra time, then other people don't get a chance to speak. This is the problem.
so therefore, half an hour.
Certainly, it'll end on Tuesday.
And half an hour for Mr. Dwivedi, half an hour for
Supposed to
Mr.
be a
Seyu
liberal
Singh.
time period even by any standards.
And after Mr. Chandra Singh, who will argue? Mr. Gopal Shankar Narayan.
My name has been there after Mr. Singh.
So what we do is, Mr. Dinesh Dwivedi, Mr. Seyu Singh, Mr. Gopal Shankar Narayan, and Dr. Menaka. One second. We are laying down a time schedule. The four of you, between yourselves, please ration the time so we complete your submissions by lunch on Tuesday. And then we'll give a little, another half an hour or 45 minutes to everybody else.
Lord, it will be of great help in reducing my time, Lord. If Lordship would go through during this, Lord.
I think what we'll do is,
Then Lordship can put the direct question to me
right,
and ask.
what we'll do is we'll go through the written submissions of Mr. Dwivedi and Mr. Seyu Singh. And possibly Dr. Guruswamy and Mr. Shankar Narayan, any particular aspect of your submission that you would like us to focus on, because now you'd be covering things which are left out by the others.
No, but if I can just make one small submission, if your lordships have noticed, everybody on this side, there's hardly been any repetition or overlap, despite the amount of time that's been taken. And the reason I'll explain why. On day one, I told your lordship the number of pages that were involved. Your lordships have been shown only, I think, about 10 or 5, even less than 5% of the documents involved. Well, the rest of it, I'm afraid your lordship may have to go through. What we are doing, personally, I'll tell you what I'm doing. I'm putting down what I would like your lordships to read on your own, because it's going to take way too much time for me, perhaps, to take your lordships through it. There are, in fact, large swaths of material that needs to be shown, but we don't have the time.
Can I suggest one thing?
Yes.
Without giving us, like a million pages,
Yes.
if you can say by tomorrow afternoon, give to the court master on a piece of paper, what are the specific aspects you would like us to, from your submissions, as Mr. Dwivedi has given us,
Yes.
just highlight that. I'll circulate it to all my 4 colleagues,
Yes.
so that then we know exactly what is the area you're focusing on. So we'll be also ready over the weekend. We have those 2 days apart from the Monday reading. We'll focus on that. So we'll get through with the submission, so that will curtail ultimately the time which all of you are. So we proceed on the basis then that Mr. Dwivedi, Mr. Chandra Singh, Mr. Gopal Shankar Narayan, and Dr. Menaka will conclude.
After that, probably my turn was there, then I think because we've all been locked in.
All right, you tell us. No, all right, you tell us what is the sequence now.
I'll take half an hour.
No, it's.
Parekh, the sequence can be, that is why I said Mr. Gopal Shankarayan can put down, you have so many minutes in Tuesday. How much minutes will each of you take? So that it should not be that anybody is left out by the end of the time.
So, Mr. Shankar Narayan, what you can do is, we are concluding this side completely on Tuesday. Please sit with whoever is in the court. You give us on Tuesday morning the sequence and allocation of time, so that we strictly stick to the time, and we conclude on Tuesday at 4
I
o'clock.
suggest that I go last if I'm the one doing that, because I don't want there to be any allegation that I favor.
Oh, no, not at
I'll go
all.
last.
I don't think anybody will do that. You've been there sitting there, and you've been making notes and assisting everyone. But now when your turn comes, but give us that on Tuesday morning upfront, so that, in fact, if you can ideally give it to us tomorrow morning, give it to our Mr. Sanjay, our court master. I'll circulate it to all my colleagues. So we know Tuesday morning, and then we keep to that order, the sequence and the time. So there's, everybody feels that, they have, of course, no difficulty. Absolutely no difficulty at all.
If possible, I'll mention the issue.
You can even mention the interveners. Who are the interveners? Between the interveners, no difficulty. You can just right now sit with Mr. Shankar Narayan for 5 minutes after we rise, so that he can just prepare the blueprint for us.
I'll do that.
Please, one thing, this is a little bit of, self-restraint. We'll give 10 minutes, but 10 minutes provided you're saying something which is different from what somebody has argued, then don't cover the same territory. We had that, we still have it, but now we are towards almost the concluding stages of the argument. So now everybody, each one of the council following knows this is the time stipulated, and so that, we conclude on Tuesday. Otherwise, what will happen is the last 2 or 3 council will have very little time left. That should not happen. Like to ration out time for everybody, including the interveners. Mr. Shankaran, just do that, and if you could kindly give it to Sanjay by tomorrow morning, so he'll have it. Thank you.
Yes.